Okay, we're live.
Okay. And just as a reminder to all our commissioners, this meeting, as all the commission meetings, is being recorded. And as you just heard, we are being live streamed on YouTube. And Judge Wilson, whenever you're ready, I have been doing the roll call as members were admitted to the meeting. So we do have a track and we do have a quorum. I see Delegate Bartlett just in the waiting room, so I'll admit her right now, but we have reached a quorum.
Okay, once she comes in, we'll get started.
Great.
Right, let's see. Yep, there we go. All right, well, thank you all for taking time to join us tonight as we enter the legislative session, which always proves to be interesting as the current members of the legislature will attest to you. Tonight, I believe we're just reviewing HB 412. Is that correct?
That is correct.
And it's a Transparency Act bill filed essentially by the governor's office that we did debate long and hard last year as well. And what I'd like to do is let David do a synopsis of the position the committee took last year with any notable differences from this year's bill versus last year's bill.
Thank you, Judge Wilson. So I just asked the committee members to bear with me. My introduction is a little bit long, but I hope you don't mind. I just want to make sure I am adequately relaying the primary background for this legislation. We do have 7 new commissioners since this bill was last considered by this commission. And actually it wasn't last year. It was 2 years ago. Last year it was a skip. So as we know, the purpose of this conference call is to discuss House Bill 412 and the cross-filed Senate Bill 392. This legislation affects the operations of the commission, and therefore, according to our policy, this meeting was arranged for the purpose of soliciting feedback about this proposed legislation. And to start with a review, this legislation combines separate legislation that was previously introduced during the 2020 session, specifically House Bill 355, the Judicial Transparency Act 2020, and House Bill 1458, which is the Truth in Plea Deals Act of 2020. This legislation includes 2 distinct requirements. The first is to require the Sentencing Commission to provide in its annual report case-specific information for sentences for crimes of violence, including information identifying the sentencing judge. The second major component is to revise the definition of a guidelines compliant sentence, such that a sentence imposed under a binding plea agreement that is above or below the recommended guideline range would no longer be considered compliant. And I'm going to summarize the impact of those 2 separately as they are unique and distinct requirements. So I'll start with the review for the new reporting requirements that start on page 4, line 26 of the proposed legislation. House Bill 412, Senate Bill 392 requires the commission to review each case or sentencing event involving a crime of violence as defined in Criminal Law Article 14-101 and provide the following information on each conviction in the Sentencing Commission's annual report: the crime of which the defendant was convicted, the sentence imposed, the applicable guidelines range, the disposition of the case, the amount of time suspended, and the percentage of the sentence suspended for convictions in which a portion of the sentence was suspended, the departure reason when applicable, the court and judicial circuit with jurisdiction over the case, and finally, the sentencing judge. Now, the Sentencing Commission collects most of the data on each of those reporting requirements, or some version of those requirements, except for the sentencing judge. The guidelines worksheet has an entry location for the judge's name, but the judge's name is not collected or reported in the Maryland Automated Guideline System, what we refer to as MAGS. Rather, a space is provided in the bottom right-hand corner of the guidelines worksheet PDF. This is where the judge can provide a signature on the final printed copy that is maintained for the court records. However, the printed copy is never submitted to the Sentencing Commission. Therefore, the commission does not maintain a record of the judge's name. This legislation would necessitate a change in the Sentencing Commission policy regarding collection and reporting by individual judge. The Sentencing Commission would need to amend MAGS to report the sentencing judge. MAGS programmers at the Department of Public Safety and Correctional Services estimated in 2020 a cost of $10,000 for programming, development, testing, and documentation to implement the necessary changes. Now, we did a review of our guidelines database and looked at fiscal year 2019 to get an idea of how many counts or convictions we would be talking about for crimes of violence. In 2019, we identified 2,756 counts, which equates to 1,788 individuals sentenced for a crime of violence under 14-101 of the criminal law article in the circuit courts. We used 2019 for this analysis because that was the last full fiscal year of data before the COVID-19 pandemic, when we all know the number of sentencings was reduced dramatically. So we thought it would be best to go with a full year to get a full assessment of what the impact would be. Given the volume of cases, the proposed legislation will require additional staff resources to comply with the new reporting agreements. Next, I will review how this legislation, starting at line 14 of page 4, revises the definition of a guidelines compliant sentence by indicating that a sentence imposed pursuant to a plea agreement may not be deemed to be compliant with the sentencing guidelines unless the sentence falls within the actual guidelines range. So to put the impact of this legislation in perspective, I think it's helpful to review again how guidelines compliance is calculated. So for each offense category, a separate matrix contains an individual grid cell that provides a recommended sentence range for the defendant based on the criminal history and the seriousness of the offense. We deem a sentence compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention, falls within the applicable guidelines range. Additionally, a sentence is deemed compliant if the judge sentences an offender to a period of pre-sentence incarceration time with no additional post-sentence incarceration time, and the length of that pre-credited time, the credited pre-sentence time, exceeds the upper guidelines range for that sentencing event. The commission also deems sentences to corrections options programs, for example, problem-solving court, health general 8507 commitments, et cetera, as compliant, provided that the initial sentence plus any suspended time falls within or above the guidelines range, and the sentencing event does not include a crime of violence, child sex abuse, or escape. Finally, in 2001, the Sentencing Commission adopted a policy designating ABA binding plea agreements as guidelines compliant to acknowledge that these type of agreements reflect the consensus of the local view of an appropriate sentence within each specific community. As you all know, or most of you know, they're with us during this time period, we studied this issue. We observed variation from court to court regarding the level of specificity required for a plea agreement to be considered an ABA plea. So for example, in some courts, it was noted that a binding plea agreement may include agreement to cap the sentence at the upper range, or an agreement to some broad range within the guidelines, or not, maybe even outside the guidelines. Accordingly, in 2020, the Sentencing Commission completed a study of binding pleas that included a review of definitions of binding plea agreements from other jurisdictions and examined relevant Maryland case law and analysis of sentences for guidelines eligible cases over a 3-year period. As a result of that review, the commission in December of 2020 replaced the term ABA binding plea, or we voted to do this at that time, with the term MSCCSP binding plea agreement, and defined the term MSCCSP binding plea agreement to clarify this concept for the Maryland criminal justice practitioners. At the time, we defined a MSCCSP binding plea agreement as a plea agreement presented to the court in agreement by the attorney for the government and the defense attorney or the defendant when proceeding pro se that a court has approved relating to a particular sentence and disposition. Further, the Sentencing Commission tightened the definition to indicate that an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, and not merely a sentencing cap or range. Now, the agreement is binding on the court under Maryland Rule 4-243C if the court accepts the plea. The binding plea agreement and corrections option compliance policies allow the court to set a guidelines compliant sentence that considers the individual needs of the offender, such as substance abuse or mental health treatment. And those revisions that were thought out by the commission and voted on were adopted effective April 1, 2021. Now, in January of that year of 2021, prior to the start of the General Assembly session, the commission sent a letter to the legislature outlining the steps the commission took in 2020, and in it noted how these steps address concerns that inspired House Bill 1458 from the 2020 session. The letter noted that one of the main goals of sentencing guidelines is to help to ensure consistency in sentencing. The letter further noted that the commission believes the revised guidelines and the terms for guidelines compliant pleas will reduce the number and percentage of pleas that are considered guidelines compliant, because judges may choose to accept the binding plea terms only if he or she agrees with a specified amount of active time that was presented in agreement by both the state and the defense. Looking at the guidelines database for fiscal year 2021, so the most recent fiscal year of data, this is the same as what we just reported on in our most recent annual report. We noted that 42%, just over 42% of sentencing events were in the Maryland Circuit Courts were resolved by a binding plea agreement. So we're calling it binding plea agreement here because it was both ABA pleas and or MSCCSPs, because the change took place in the middle of the fiscal year. Well, at the end of the fiscal year. Among the 42% of sentencing events resolved by a binding plea agreement, 55% were within the recommended guidelines range, 37.9% were below, and 7.2% were above the guidelines range. In the prior fiscal year, 2020, just less than 49% of sentencing events were resolved by a binding plea agreement. So the percentage of sentencing events that were adjudicated with a binding plea were reduced in fiscal year 2021, which is kind of what we expected. Even though the new rule was only in effect for the last 3 months of fiscal year 2021. Now, I should note that we have to interpret any data from fiscal year 2021 with caution, because the number of sentencings were, as I previously noted, substantially reduced across the state due to the COVID-19 pandemic. And the biggest decline in sentencings was observed in the 8th Circuit, where binding pleas are most common. However, it may be worth noting that given the commission's decision to adjust the sentencing guidelines for drug and property offenses to better reflect current sentencing practices, many sentences adjudicated via an MSCCSP binding plea agreement that are currently outside the guidelines range, or that were previously outside the guidelines range, should become guidelines compliant with those pending revisions. If House Bill 412 or the cross-filed Senate Bill 392 were enacted, it would eliminate the MSCCSP binding plea agreement policy, as well as the pre-sentence incarceration compliance policy and the corrections option policy in cases that involve the plea agreement. As you all know, upwards of 95% plus percentage of cases are adjudicated by plea agreement. So it would eliminate, this legislation would eliminate for the majority of those cases as well. The proposed legislation would require the Sentencing Commission to amend MAGs, just as the first portion that I talked about would. Those will require an estimated $8,750 to support programming time. So in total, between the two changes, just less than $20,000 for MAGs programming changes. Further, the proposed legislation would require additional staff resources to comply with the new reporting programs that I mentioned in the first part, and the change in the definition of sentencing guidelines compliance. There would be a lot of really kind of back and forth data checking, communicating with the judiciary, testing and implementing MAGs changes. So a lot of additional staff times that would be required. So in light of that, to handle these extra responsibilities, the commission did ask for requested funding to hire one full-time research analyst position, and that was noted in the commission's fiscal and policy note that was submitted in response to this legislation. So next, I just wanted to summarize, as Judge Wilson noted earlier, the commission's previous position. We have 7 new commissioners since versions of this legislation were last introduced in 2020. So for informational purposes, I will summarize the previous position of the Sentencing Commission. In 2020, the Sentencing Commission convened to review House Bill 355 / Senate Bill 272, which was the Judicial Transparency Act of 2020, and separately to review House Bill 1458, which is the Truth in Plea Deals Act of 2020. Now, with respect to the judicial transparency legislation, the majority opinion held that the commission should oppose that legislation for 2 primary reasons. First, the majority believed that the requirement to report sentencing information by individual judge conflicted with the enabling legislation of the Sentencing Commission. Specifically, Criminal Procedure Article 6-202 instructs that the sentencing guidelines should be voluntary, and it further states that sentencing policy should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. In 2020, the majority expressed opposition to House Bill 355 because they believed that publishing judge-specific sentencing data would potentially change the nature of the sentencing guidelines from recommendations to edicts. The second primary opposition noted in 2020 was that by requiring the commission to publish judge-specific reports, the perception of the commission would shift from its current role as an objective manager of the sentencing guidelines to a role of monitor of individual judge performance. At that time, it was noted that the role of the Sentencing Commission was never intended to be that of enabling the grading of the performance of any trial judge. Rather, it was noted that the guidelines and the corresponding data collected via the guidelines worksheet were designed for general policy development rather than for monitoring individual judge behavior. Now, regarding the second portion of the bill pertaining to binding plea agreements, the Commission in 2020 asked the legislature to defer on taking any action to give the Sentencing Commission time to study the issue. Now, as I previously noted, the Commission completed that study at the end of 2020 and enacted revised definition for binding plea effective April 1, 2021. The Sentencing Commission's most recent annual report included data for fiscal year 2021, which covers July 1, 2020 through June 30th, 2021. Accordingly, the reporting period had only 3 months of data since the adopted revisions for binding pleas on April 1, 2021. Pursuant to the policy adopted by the commission is meeting tonight to review legislation that directly affects the operations of the Sentencing Commission or the sentencing guidelines, and to request a vote on whether the commission will support, oppose, or take no position on the proposed legislation. The Sentencing Commission is not obligated to assume the same position as taken in 2020. The commission membership has certainly shifted some, and support for publishing judge-specific data has also somewhat shifted. The Sentencing Commission may choose to take no position on the bill, or it could choose to support or oppose the separate portions of the legislation. So just for example, the commission may choose to submit an information-only written response, or the Sentencing Commission may choose to propose an amendment whereby the commission collects the judge-specific data, does not proactively publish a report with judge-specific identifiers, but instead makes the data available upon request. Another consideration is that maybe for the commission to respectfully request the legislature to defer on the plea agreement portion of the legislation to allow the commission time to assess the impact of the April 1, 2021 revised definition of guidelines compliant pleas. And before I wrap up, there's just one final issue that I wanted to highlight. And specifically, it is important to note that this legislation is marked as an emergency bill. And as an emergency bill, if passed, it would take effect shortly after the conclusion of the General Assembly session in April. However, the requirements of the legislation are not things the staff can immediately implement. The practical reality is that it would take a minimum of several months before we could reprogram MAGs or capture the necessary information, and then revise the data collection. Then the revised data collection would just start at that point. So first, MAGs would need to be amended to capture additional reporting details and to change the guidelines compliance calculations. But we already have major updates for MAGs planned for the release of July 1, 2022, including, and not limited to, the revised matrices for drug and property offenses, a new streamlined sentence screen to make it easier to enter sentence information, and an update to the whole application to make it more mobile friendly, so it's easier to view for instance, on a phone or a tablet. Those are significant updates that are currently being worked on by DPSCS programmers and our staff, and they must be meticulously reviewed and tested prior to deployment. It would be difficult to implement the necessary MAGs updates prior to July 1, 2022. It's more realistic to expect updates to being implemented closer to, I think at the earliest, October 1, 2022. And as noted, the commission will also need to hire new staff to address some of these responsibilities. And we would need time, obviously, to get a position approved by the university, advertise a position, interview, and hire. So the absolute quickest that would happen is 2 to 3 months. And we'd also need funding for the position. So just wanted to kind of share all those and what that means in terms of what being emergency legislation. I will conclude by noting that the hearing for House Bill 412 in the House Judiciary Committee is scheduled for tomorrow, February 8th at 1 p.m. The hearing for the cross-filed Senate Bill 392 in the Senate Judicial Proceedings Committee is scheduled for Thursday, February 10th at 1 p.m. So based on the current guidelines for both committees, any written testimony will need to be submitted by tomorrow morning at the latest. Technically, the deadline for the Judiciary Committee already passed, but Delegate Klippinger graciously granted us a one-time exception, so we could proceed with our meeting this evening. So that concludes my report. I'm happy to stop talking at this point, but I obviously recognize that there may be questions, and we can certainly open it up for discussion.
Questions for Dr. Saleh? Yeah, go ahead, Rick.
Hey, David, obviously there are administrative, practical issues and policy issues that we should address. You think we should break it down right now, or are you sort of in control of the administrative, practical issues?
I think the administrative practical issues we are in control of. We did submit the fiscal note request. We can talk that through. I just wanted the commissioners really to be aware that there is a fiscal number that would be attached to this legislation in terms of MAG's programming and the proposal to hire a new full-time research analyst. So that's the request that's been submitted. If this legislation were to pass, we have another challenge to then go to the governor's office and be to say we made the request for the funding, but we also have to do our best to convince them that the funding should be granted to the commission. It's not an automatic, I know that, but I'm just saying it's not an automatic. You ask for, you project what is needed, but we would then have, if it passes, also have to just obviously.
So as a commission, we need to address the policy question again. That's the
I think that should be the primary focus. Yes.
Okay, well, thoughts as to the overall policy, obviously the most poignant part of this is the personal identification of judges. We did have a robust debate a couple of years ago on that topic. The commission at this point, as Dr. Saleh said, has changed a good bit. So would any of the newer members like to weigh in with thoughts or questions about that specific part of the bill? All right.
I see Delegate. Yeah.
Oh, yeah, go ahead.
Thank you, Mr. Chair. I apologize. I'm going to have to leave in a few minutes, so I just wanted to quickly say, I believe the last time around we had a bill like this, I abstained from taking a position because something seemed a little awkward about voting to get this group to try and influence a bill that was about to come to me the next day, and that's where we are again here. That being said, I've always had grave reservations about this, especially given some of the stated goals for what this identification of individual judges is supposed to achieve. And I gather some would like to encourage judges along for longer sentences or something of the like. And so that's not generally my outlook on how we do these things. That being said, I will, there's sort of an elephant in the room on the context here. And I would note that in the leadership priorities and discussion from the chamber leaders, you will see judicial transparency now is among the session priorities. I'm not sure that means this bill, but nevertheless, this bill and some of the conversations are obviously creating a second look at this issue in the current climate. So I'll just renew my abstention, but also renew my reservations about what this bill is trying to do, and I will you will likely see me express my fuller opinion when this comes before the committee.
Noted.
Yes, so Delegate Moon is correct about the general push or use of the word transparency and quite frankly, different approaches to the criminal and civil justice systems. I serve on the Court Access Committee for the Judiciary as well. And transparency specifically on the civil side when it comes to rent actions and some custody matters and other areas of law is coming to the forefront as well, but in a much different vein than this. So, all right. Judge Avery, do you want to go ahead and I guess lead the discussion on this with your point of view from Baltimore City and judiciary generally?
Sure. I mean, I have testified on behalf of the Maryland judiciary in opposition to this bill over the course of the several years that it has been introduced. So I know I should go over all of these points systematically, but I feel like I've been talking about this incessantly now for so long. I of course agree with the previous position that the commission took, that this legislation encroaches on judicial discretion in a significant way, because it sets up the Maryland Sentencing Commission as the mechanism for creating what is in effect a report card on individual judges. And that report card is very misleading to the public. So, you know, the idea of transparency, in my view, is a little misleading, because what this creates is a report card on one fact, and that is the relative length of the sentence. So it doesn't create transparency or accountability with regard to the myriad other factors that exist in a criminal sentencing procedure. So it doesn't take account for the restorative or conditions of probation that meet or address the criminogenic needs or the criminogenic profile. You know, judges are required by constitutional due process to consider all of the relevant factors that relate to sentence: victim, defendant, circumstances of the crime. It's essentially, according to all of the case law in Maryland, other states, and the Supreme Court, the judge is required to consider all the factors. The legislation, in addition to creating what I view as a due process problem by encroaching on judicial discretion and trying to create an environment where judges are guided toward a more rigid approach to sentencing, it also is going to eliminate our guidelines compliance rule with regard to pleas. That is, I think, a very serious issue from a policy standpoint that creates a public safety problem. It also creates a separation of powers and due process problem, because plea agreements are brought before a judge as the result of negotiations between the defense and the state's attorney. Why would a state's attorney negotiate a plea that would allow for a sentence that is below the normal guidelines? Well, there are a number of reasons that the prosecutors in this room can mention to you. One, you have problematic legal issues with regard to your policing or the investigation. You have reluctant witnesses. In Baltimore City, I can tell you that the reluctant witness problem is because many witnesses are afraid to come forward because they feel their lives are at stake in their communities. Obviously, domestic violence and sexual assault survivors are afraid to come forward for safety reasons, as well as all of the other obvious reasons. So why does a prosecutor negotiate for a lower sentence? Because they either feel that their case is weak, that they can't win the case in trial, or that they have problems with their witnesses that they don't want to go forward. This is an issue of prosecutorial discretion. The judge is not permitted to get involved in the negotiations. That is by case law from the Court of Appeals in the Sharp case, but it is also a requirement of our guidelines compliance rule with regard to pleas that the judge does not make a judge offer. There's no judicial involvement in the negotiation. The judge either accepts the plea as it's negotiated by the parties or doesn't. So by holding the judge accountable for a lower than guideline sentence in plea agreements, you're going to see a discouragement of pleas being accepted. We are elected officials and we stand for election. And, if judges are going to be excoriated and held responsible for these sentences, I think what you're going to see is a shift against accepting pleas that will create a backlog of cases in the judicial system. And it will also create a public safety problem, because very often it is much safer to have an overall lower incarceration sentence as long as you have the person on probation and they're under the supervision of the state. So, I know that the proponents of this bill, I think people sincerely believe that the violent crime problem in our communities is the result of judicial sentencing, like low sentencing. And that is statistically wrong. It is statistically not the case. I've done I'm not a statistician, but I've done my own numbers on this based on the Justice Department violent crime numbers just in Baltimore City alone. And judges sentence defendants in less than 0.5% of all of the violent crimes that are perpetrated in Baltimore City. There are so many levels of intervention when it comes to violent crime before you get up to the top of the pyramid of the criminal justice system, which is where the trial and the sentencing event occurs. So I'm happy to address any questions, but I think that one more thing I need to say. I have not opposed this type of legislation that would be directed at the judiciary. So if the legislature wants to come to the judiciary and say, we want the data as it relates to your individual judges and their sentencing. I mean, I don't think it's a good idea, but that's not really, the judiciary hasn't come out and said, you can't have our data, you can't have our information. What I think is a problem for this independent commission is that the legislature is coming to an independent commission to get the data about the judges. And that is a problem existentially for the commission because it goes against our mission and it also is going to harm our relationship with judges on whom we depend for our data and analysis. I'll leave it there.
Okay, let me just ask this because there has been seemingly not a lot of interest in discussion or questions so far. As Dr. Saleh outlined the prior position that the commission took, which was opposition, and primarily because a couple of reasons. One, it certainly intruded on what is the original mission of the commission to report statistically more than to take a position as to whether any particular judge is doing his or her job appropriately. Do we need to debate further, or is there a motion to basically adopt the prior position? I don't think anyone needs to stay longer than we have to, but if we're in the position, go ahead, Judge Avery.
Well, I would so move to adopt the prior position.
I would second.
Okay, now, before we go on, is there any further discussion or concern about adopting that position?
So Judge Wilson, I do know Senator Sidnor had his hand up to speak, and I see it's up again.
All right, Senator Sidnor, did you want to go ahead? This is opposition to discuss the motion. Go ahead.
What I was going to suggest, and I've seen a number of agencies do this, is simply to propose or to submit letters of information rather than taking one position one way or the other. And that I was going to suggest that might be a way that you all may want to proceed.
Well, and I'll tell you, Senator, without opening what could go from a shorter meeting to one that will last the rest of the evening, 2 years ago, I suggested that we take no position and do something like that. And quite frankly, I think that got us into about 2.5 hour discussion. So I appreciate that the letters of information approach. If I'm reading the room right, it seems that a majority are comfortable with taking a position in opposition based on the reason stated and the position that was stated as of 2 years ago. Is there any opposition to doing it that way?
If the committee is going to go that way, I'd take the same position as Delegate Moon, and I abstain since I have not heard the discussions yet.
No, that makes sense. And I know you'll be active in. Go ahead, Delegate Bartlett.
And frankly, I suppose I should too.
Okay.
I froze. Sorry. I was saying that I should probably do the same. Just, because it's prudent, and my senator and my vice chair has stated that I should do it that way. So I'm going with them.
No, I think it does make sense because we don't want you to lock yourself in a position before you've heard it on the floor or in committee. So thank you. All right. Anything else before we call for a vote? All right.
Well, one thing I would note, well, Delegate Wilson, I suppose we could call for a vote first. And then we do need to talk about what that testimony would be, because it would need to be submitted by tomorrow morning. So the staff will have to, I don't know that we have time to circulate it. We could basically, we could just reiterate the opposition from 2020
right.
That was pretty short, sweet, and to the point. And we could do that. The one thing that we, and if you'd rather do this after a vote, Senator, I was just going to read a potential opposition statement, because the only thing that's different this time is that there's the second component, which is, and the staff was thinking that the commission may want to, regarding the second component, to respectfully ask the legislature to defer on that portion. And I know I'm kind of taking us, so it would be to oppose on the judicial transparency, but to defer on with the respect to the pleas, because the commission has taken actions on those, and we just have 3 months of data now. And I think it would really be helpful to know what a full year's worth of data looks like with respect to that. So we could take the vote, but I just wanted to see if I could get the commission. I don't think I have time to circulate written testimony to the full commission, get approval, and get it submitted by tomorrow morning.
Okay, well, let's go ahead and take the vote as indicated on the judicial transparency. I think you're right, Dr. Slay. I think the push to defer or ask for a deference on the plea side would be appropriate, but I'll do it in the negative. Is there anyone opposed to the motion to adopt the position of opposition that was stated in prior submittals of the legislation. Anyone opposed, please raise a hand or signify by saying nay. Okay. I think you have it there, Dr. Slay. Other than the abstentions, you have unanimity.
Okay.
All right. And Dr. Slay, I do apologize. I'm backing up against the family commitment as well. I know everyone is busy, and I don't mean to beg out on this, but as far as the second component, what are you asking the committee to vote on, I guess?
So if with your permission, I could just read we drafted testimony, and it's short, sweet, and to the point. I could summarize it, and I just wanted to get the committee to sign off on that here, knowing that we will not really have time to send out this to everyone.
Right.
So the letter would read that the commission convened via video conference on February 7th to solicit feedback on this. X number of 19 commissioners participated by a majority vote of whatever the tally is, or I could say no opposition. The commission voted to oppose House Bill 14 and its cross-reference Senate Bill 392. A majority of commissioners voted to oppose 419/Senate Bill 392 because the legislation is inconsistent with the commission's historical and statutory purposes. Sentencing guidelines are voluntary and were never intended to pose an absolute limit on judicial discretion or to gather and or publish judge-specific sentencing information. Further, effective April 1, 2021, the commission narrowed the definition of what constitutes a guidelines compliant binding plea, specifying that such pleas require agreement from all three parties, the judge, the prosecution, and the defense, to a specific amount of active time, if any, not merely a sentence cap or range. This revision followed a comprehensive study by the Commission of binding pleas that included a review of definitions of binding pleas from other jurisdictions, examination of Maryland case law, and analysis of data for guidelines eligible sentencing events from 2017 through 2019. The commission appreciates the legislature's concern and respectfully requests that the legislature defer to allow the commission time to assess the impact of the April 1, 2021 revised definition of guidelines compliant binding pleas. So that was the testimony that we drafted in its entirety. It basically is the same testimony that was submitted in 2020, except for adding on the latter portion about binding pleas.
I think it sounds great. Any concern or comment from the panel?
The last portion then would be, assuming that hearing none is an approval of that,
Yep.
is submitting. So we would go ahead and submit the written testimony. Would the commission want any one of the commissioners to testify in person at the hearing on Tuesday, and then the subsequent one in the Senate on Thursday?
Okay. What time is it set for?
1 p.m. on both
1 p.m.
days. It will be virtual. Maybe that isn't obvious, but.
And also on the for tomorrow, it's set for 1 p.m. I'm going to look at the order real quick to see when it's coming. What happens is, even though it's set for 1, it
Right.
don't actually necessarily hear it at 1.
Right.
So I'll do that really quick. I'm going to look at how many witnesses we have, and that'll give us some idea about how long we're going to be before we actually hear the bill. Just give me
And Dr. Saleh, I do have to get going. I will be available virtually tomorrow or Thursday if needed to testify. I'll be glad to present the position, but I'll leave that up to you. And I can talk to you more about that in the morning. And again, members, I do apologize that I have to leave before 8 end, but I appreciate everyone's participation.
All right. Thank you, Judge Wilson.
Thank you.
Yeah, so we would be able to sign up tomorrow to testify on the House side. And actually, we have to sign up tomorrow to testify in the Senate side as well. And so you have to, each individual speaker does need to create a My MGA account and, express their position and do that individually. So like I would be able to sign up Judge Wilson. I can communicate further more with him, just to double check that, but I can sign him up. But then like anyone else, you can't sign up as a panel is what I'm saying. And each individual person needs to sign up based on the new rules that were adopted this year. Is that right, Senator Sindor? I think I have that right.
That is correct.
Okay.
In terms of the hearing in the Senate on Thursday, it looks like this bill is towards the very end. So
Yeah.
I'd say closer to 3, 4, 5 o'clock, maybe, but not 1.
Right. Okay. Thank you for the heads up on that.
How many? Go ahead, Delegate Bartlett. Go ahead.
I was just saying, we're third, this bill is third on the list. And we have one bill before that's going to be a kind of
Okay.
Yeah, I would estimate that you'll actually be on probably around I don't know, I'm going to say 2.
Okay.
It's unpredictable. I mean, it's just, it depends on questions, and all of that. So we tend to go very long in judiciary, as you all probably know.
Right. Correct. Well, all right. That's good to know. I mean, I can communicate further with Judge Wilson. I think we can plan to have him sign up and present the position of the commission, which is great. And I think that should be sufficient, and we'll also have submit the written testimony as well. So I think they were good. I failed to ask for a motion to approve the minutes from the December 7 public comments hearing. So if anyone didn't mind, just another three or 4 minutes here, could we? Did anyone get a chance to review the minutes that were distributed? There's 2 sets of minutes, one for the December 7th, 2022 public comments hearing. Did everyone get a chance to review them? And if so, were there any comments or edits needed? And if not, is there a motion to approve those minutes?
Motion to approve.
Thank you, Lisa. Second.
I'll second.
Thank you, Mr. Zaremba. So those are approved as submitted. The second set of minutes is the same from the same date, the December 2021 business meeting. Are there any comments, edits, suggestions for those minutes? And if not, is there a motion to approve the minutes as submitted?
I'll move to approve.
Great. Okay, I think we got both Ms. McNally and Mr. Zaremba to appreciate that. So those are approved as submitted. So I think that will conclude our meeting for this evening. I greatly appreciate everyone's time this evening and making time in your schedule. I know this was a last minute thing, so I do want to let you know that I really appreciate you all taking time out of your schedule to be available to have for this special evening meeting. And obviously after the hearings, I will probably send out an email to keep you all apprised of the situation and what we can expect of the legislation moving forward. So thank you, everyone, and appreciate it. And have a great rest of your night. Take care.